So the next case we'll talk about is Baker versus Carr. This is a case we've talked about as it relates to our unit on Congress. It's about congressional apportionment. And it really, at the end of the day, really solidifies the concept of one person, one vote. So the basic facts here is that a state legislative district plan in the state of Tennessee is challenged as a violation of the Equal Protection Clause of the 14th Amendment. This is the constitutional clause involved. 14th Amendment says no state, among other things, no state will deny equal protection of the laws. And so this is a clause that is used in many, many court cases when there's arguments that people are being treated unequally. In the case of Tennessee, they had districts that were radically different in size. Some districts, with 100 to 1 ratio, more people in them. And of course, the people in these districts felt that they were being discriminated against, and the fact that many of the larger districts had more minority populations in them to dilute their voting power made it even more of an argument that the Equal Protection Clause was being violated. Now, one of the keys to know about Baker versus Carr is that it was about state legislature, the state government of Tennessee. But it sets the precedent that this is an issue that can then be expanded into federal districts as well. So then there are future cases that rule that federal legislative districts for U.S. Congress seats also need to be of equal size. So really important case about congressional apportionment. Obviously, it makes sense to know what apportionment is, how it works, how every 10 years the congressional seats are reapportioned among states depending on census results. But the state legislative districts and the congressional districts for the national government are drawn by state legislatures. That's a really important thing. The state legislatures have power, but the federal court ruled in Baker versus Carr that they could hear cases about this, especially if they felt the 14th Amendment of the Constitution was being violated. Now, related to this issue of drawing legislative districts is the Shah versus Reno case of 1993. Also a Congress case. This is about districting as well, but in this case, we're talking about the issue of gerrymandering. We're talking about the issue of when state legislatures draw districts in a specific way to give an advantage to one political party. In North Carolina, the legislative districts in the early 90s were drawn using race as a factor in where people would be placed, what districts they would be placed, and there were a number of districts, one in particular that was drawn in such a strange fashion. And it was actually done in order to create a majority-minority district, in order to put African Americans into a district, in order to make sure that they had a representative. But this was challenged as a violation of the Constitution, and the Supreme Court makes the ruling that you can't use race as a primary factor in gerrymandering. They don't say gerrymandering can't occur. They don't say gerrymandering is unconstitutional. In fact, it's an issue that continues to be litigated in the courts today when gerrymandering occurs for obvious partisan purposes in states around the country. But when it's drawn with race as one of the main demographics that's used to draw the lines, then it becomes very, very suspect in the eyes of the courts, and they say it has the potential to violate the Equal Protection Clause of the 14th Amendment. So gerrymandering occurs, but race can't be used. That's one of the significant precedents here, and one of the significant outcomes of this particular case. The last case we'll cover in this video is Marbury versus Madison. This is on our unit on Congress, and it is arguably one of the most important Supreme Court cases that has ever occurred because it established that the court had the authority to strike down laws of Congress or strike down actions of the executive, or in essence, exercise the power of judicial review. Now, the basic facts, we can keep this basic because it's a really muddled, complicated story that we don't need to get bogged down in. But what we do need to understand is that a case came before the court directly because Congress had changed the court's original jurisdiction in the Judiciary Act of 1789, saying that the court had authority to hear certain cases about issuing judicial orders. And this was all about the appointment of officials at the end of the John Adams administration and into the Thomas Jefferson administration. The clause that's involved in the Constitution is Article 3. Article 3 establishes what the original jurisdiction of the court is. And it says very clearly that they have jurisdiction over cases involving ambassadors, over disputes between states, over issues of maritime jurisdiction. When the Judiciary Act of 1789 is passed, they set up the court system, and they altered the original jurisdiction of the Supreme Court and said the Supreme Court can hear cases on certain things and they can issue orders on certain things. The Marshal Court, although they actually reduced their original jurisdiction a little bit by saying the Judiciary Act doesn't give them certain powers, because it can't give them certain powers, they dramatically expand the power of the court by saying, we're striking down that part of the law. We're saying that part of the law is unconstitutional. It's not in the Constitution, the power of judicial review. It's not established that they have the authority to strike down laws as unconstitutional. So Marbury versus Madison does just that. They strike down a law as unconstitutional. They say you can't modify the Constitution. It's all about Article 3 of the U.S. Constitution. That's the key clause. So it has a huge, huge lasting impact, because now so much of what the court does is exercise judicial review today and throughout American history. So Marbury versus Madison establishes that they have the authority to do that. We'll stop here.